What every medical professional must know about the 12 reasons why buying a disability insurance policy through an association is probably not a good idea. Every medical professional should have a disability insurance policy to protect their income and to provide them with financial peace of mind. The million-dollar question is whether you should purchase an individual disability policy through an insurance agent, an ERISA group plan, a policy through your employer, or an ERISA group policy or plan through a medical association. In this series, I'm going to address why buying a disability insurance policy through an association is probably not a good idea, and the limited circumstances where it might make sense. Ready? Many medical associations offer disability insurance policies as a benefit to their members. While on the face of it, it may appear to be a good deal, the association disability policy is not the best or the least expensive option. In fact, they can be the wrong option. There are 12 problems, in my view, with medical disability policies. First, there's a conflict of interest between the insurance agent and the association sponsoring the disability insurance policy. The insurance agent is not working for free. It isn't uncommon for an insurance agent or the insurance company selling the policy to share the revenue with the association. That can cause a conflict of interest. The agent or the association will most likely not give you an unbiased advice on these topics, nor are they best prepared to address your personal needs so that you purchase a tailored disability insurance policy. 2. The ERISA statute governs your association's disability policy. ERISA is not a friendly place for a disabled medical provider. If you have to sue the disability carrier in federal court, there will be no opportunity to present new evidence or vocational evidence in support of your claim. No discovery, no jury trial, and at best, the judge can only award your back benefits. Worse yet, the policy offered by the medical association probably has a get-out-of-jail-free card known as the discretionary clause. This clause makes it difficult for a federal judge to substitute their own independent judgment and reverse the carrier's denial. There's a presumption that the carrier's denial is correct. The only way to overturn a wrongful denial is to show that the disability company's denial is arbitrary and capricious. That's a very high standard to meet, and if you had it, you would prefer to have a de novo standard of review. An unfavorable definition of disability. You want the broadest definition of disability possible, and one that will pay you if you're disabled from performing the material and substantial duties of your specific occupation that you were performing at the time you became disabled. Better yet, you want a subspecialty definition of disability in your policy. Association policy definitions are narrower, and that means that you're less likely to meet the policy definition of disability and qualify for your benefits. 4. Legal deductions from your benefits. On the face of it, a disability policy through an association may appear to pay a high monthly benefit, but buried in that policy is a section called Other Income. That other income provision allows the medical association carrier to decrease your benefits by the receipt of Social Security, including those of your minor dependents, other disability insurance policies, monies you might recover as a result of a disability caused by a third party, like in an auto accident, and even by veterans' benefits. These legal deductions can make your policy worthless. 5. The policyholder may have to work a minimum number of hours per week at the time they become disabled to have coverage. Now that can be problematic if you're working a shift. If you work less than the required number of hours per week, you're not going to qualify for the benefits, and the carriers love to deny claims on a coverage defense. A disability insurance policy offered by a medical association is cancelable. That means that they can say, we're not going to cover you anymore. Now, they can't cancel the master policy so long as the association continues to endorse the plan and doesn't offer any similar product. So if the association decides to offer a disability insurance policy to a different carrier, you will lose your coverage. And that can be a problem if you've got pre-existing conditions. In the next part of this series, I'm going to cover the remaining reasons why buying your policy through an association is probably not the right thing to do. Picking the right disability insurance policy can be tough, even with the explanation of an experienced disability insurance agent. As a nationwide disability insurance attorney, I've helped medical professionals across the United States pick the right disability policy for them. complete a winning disability application, and take on disability insurance carriers like Mass Mutual, Ohio National, Emeritus, Principal Standard, and The Guardian. I can help guide you through this confusing process of buying a policy, applying for benefits, and taking on that disability insurance carrier. Call me today at 727-894-3188 for a free consultation. I look forward to helping you get the benefits you deserve.